Let's take a look at negligent referral. What if references are provided, but they are misleading and fail to include evidence of unfitness known to the former employer? Concern over possible defamation claims or simply the desire to get rid of problem employees might prompt some employers to provide overly positive references that misrepresent former employees to prospective new employers. Can an employer be sued for negligence in referring an unfit employee who harms others in his new job? In a number of states, the answer is yes. In one instructive case, disciplinary action was initiated against a correction officer who was accused of engaging in improper sexual conduct with female inmates, and the officer chose to resign. His former supervisors and the prison agreed to write a letter of recommendation for him. The letter was effusive in its praise for the former employee and omitted any mention of the incidents that led to his resignation. When a mental health facility called the prison, the former employee was again heartily recommended. Within a month of being hired at the mental health facility, the former officer sexually harassed and assaulted a female patient. The court decided that although voluntary, once they decided to communicate information about the former employee, they had a duty to not misrepresent him by withholding material negative information. Employers that choose to respond to requests for information about former employees should not do so in a selective or misleading manner that conceals known evidence of unfitness. At least one more significant legal concern exists regarding references. That's retaliation. In one such case, an employee was fired and filed a charge of race discrimination against his former employer. While his case was being investigated by the EEOC, the employee applied for a job with another company. The company asked his former employer for a reference. The former employer provided a damaging reference, which the employee alleged was done in retaliation for his discrimination charge. The U.S. Supreme Court decided that the former employee could sue his former employer for retaliation. Care should be taken to ensure that references provided are no more negative than the facts warrant.